Hi everyone, we've had a couple of tricky issues to advise on over the last week that are different in some ways but linked in another, and they both relate to the passage of time and trying to enforce something or make a decision under the contract of employment or a policy. So the first piece of advice relates to overpayments. The scenario is an overpayment of salary has been made, quite a significant one, perhaps over a significant period of time, and this has just been discovered some months later by the employer. So the question is, can we recover the overpayment in full? The first issue is, do we have a contractual clause in the contract? Hopefully we do, one which allows deductions to be made from wages and one which allows overpayments to be recovered. If there is such a clause, we need to look at whether there is any discretion as to whether that overpayment will be collected in full, or whether we allow that to be written off over a certain period of time. Any express clause we have, though, is also subject to our duty of reasonableness and our duty to maintain the implied relationship of trust and confidence which must subsist between the parties. So if, for example, we've overpaid somebody over a period of months, there's a couple of £1,000 that is owing back to us, and the employee's salary is a couple of £1,000 in the month, it would be very unfair to make that deduction at that point. We're saying it's permissible if we have that contractual right to make the deduction, but perhaps over a series of months, or perhaps we write off a percentage because it's our error. But we do need to ultimately try and strike an agreement with the employee. If that can't be achieved, we might decide to put those repayment provisions in ourselves, but we do have a duty to act reasonably to maintain trust and confidence in the relationship. If we don't have a contract of employment, or the contract is unsigned, or the contract doesn't provide that right to recover, we are relying on what's known as a restitution claim. So we would have to argue that there is a mistake of either in law or in fact of the overpayment, and seek to recover that through the act of restitution. The problem with that is, if it's gone on for a significant period of time, or there's been a significant passage of time, the employee's argument may well be, well, I've changed my position in relation to this. The money's been spent, for example, because I thought it was genuinely mine. And again, the issue of trust and confidence comes into play, because there has to be some fault on the part of the employee and some sympathy for an employee in those circumstances. So that deals with overpayments. We flip the issue on its head and now talk about an employee's claim, in this case for expenses. So businesses will probably have a clause in the contract that says they will reimburse expenses incurred in connection with employment. In addition, or alternatively, there may be a contractual or non-contractual expenses policy within the handbook. In the absence of both, it's generally accepted that there is a duty to indemnify the employee. So in terms of the costs that they've incurred in connection with their employment, every employer would look to reimburse those as long as they have been genuinely incurred. But what happens when an employee comes to us a year down the line and says, I've got some expenses from a year ago that I want to claim? Well, firstly, let's look at any policy that we have in place, or any clause in the contract that we have in place. It is largely untested at law, but many employers would take the approach that if the claim has not been made within a certain period of time, and the expenses would be lost, they wouldn't be repaid. As a compromise, we may simply warn the employer that they have to get them on time in the future, but that's no guarantee that will happen. Another compromise is to pay the expenses but issue a low-level warning on the basis of a breach of the policy. The final option, as we say, is to withhold the expenses if the policy allows us to do it. So if there are tight timescales for submitting those expenses and the employee fails to comply with those, can we withhold payment altogether? Now, that is a difficult one because, we have a duty to act reasonably. So we need to look at any discretion that's been exercised in the past. Do we have an inconsistent way of treating employees who submit their expenses late? If so, we're probably not exercising that right rationally. And also, if the expenses are very significant or there are other mitigating circumstances, once again, we have to look at the duty to maintain trust and confidence. An employee may argue that even if they are late with notification, if they've provided the right evidence, there's sound reasoning for being late with those expenses, and perhaps the business has taken a more lax approach in the past, the refusal to pay could damage the relationship of trust and confidence. That would amount to a breach of contract and would amount to a constructive dismissal claim. Now, in both cases, I think it's very important to know that wages are very, very heavily protected by employment tribunals. Any breach of contract relating to wages is looked on very unfavourably by the employment tribunal. And here we're talking about a very grey area of implied duties as well. So an implied duty to indemnify, implied duties to maintain trust and confidence. There is not a lot of certainty in that area, and I think if we are looking at either recovering overpayments or not paying expenses, we have to take a very reasonable approach and ideally have a paper trail that shows we've acted very consistently in the past based on either a contractual term or a detailed policy that we have communicated to staff. As I say, two very tricky areas. If you need any further advice on this, please do visit the website, chadwicklawrence.co.uk, or email employmenthub@chadlaw.co.uk. Thank you.